Hello, everyone, and welcome to today's Community Matters discussion on fair chance housing. My name is Scott Spencer, Associate Director for Advocacy and Influence here with the Annie E. Casey Foundation. The Annie E. Casey Foundation's Community Matters series explores the multitude of issues surrounding community change and the lessons we and others have learned from our work in communities around the country. Just to set the stage, in 2016, Casey published a Kids Count policy report entitled A Share Sentence, which examined the impacts of mass incarceration on kids, families, and communities. The report underscored the myriad and complex challenges faced by families with loved ones in prison. However, for many who have paid their debt to society, the return home can be equally challenging if you are unable to have a home to return to. As the report noted, quote, being able to obtain safe and stable homes bolsters child being and reduces recidivism, end quote. Yet the barriers and restrictions presented across the housing spectrum, from federally supported housing to private landlords, can literally close the door on the second chance they and their families should have. Today, we'll hear from leaders with Root and Rebound, a national organization based in California, which works to ensure that a criminal record is not a life sentence. Through direct service work, education, and advocacy, their team works to create a pathway to success for people who have been previously incarcerated. Root and Rebound's Fair Chance Housing Toolkit is one such example of their work. As you may know, issues of housing in general are complex. Fair housing, even more so. When the dimension of a past crime is added to one's housing search resume, the odds can seem daunting. Today, we'll have an overview of the toolkit as an introduction to the full complement of support being advanced by Root and Rebound. Today, our panel includes Chloe Noonan, National Legal Education and Resource Coordinator, and Sonia Tonenson, Deputy Director with Root and Rebound. Chloe will lead off with the presentation. We will then go to some of your questions before wrapping up. We hope that you will leave this conversation with new knowledge and considerations that advance your understanding of these issues and how the tools can support your work and the people in search of a fair chance in their community. Finally, to continue your engagement in this discussion, we would encourage your use of the hashtag KCChat. Let me turn the presentation over to Chloe.
From Root and Rebound, and we're very excited to have this conversation with you all today. And Sonia is going to start off by going over some key statistics and defining the meaning of fair chance housing and going over some initial concepts that we'll be going into greater depth on today.
Thank you. Thank you so much. We're really excited to be partnering with the Annie E. Casey Foundation to share this information far and wide, and just already looking at the number of people who have registered, it was something in the ballpark of 350 people who have registered. So this is really exciting for us, and I think for everyone on the phone, that there are folks around our whole country who are passionate and excited about increasing opportunity to housing. So thank you so much for partnering with us, and we're excited to be in conversation with all of the folks joining via the webinar today. My name is Sonia Tonenson. As Scott said, I am the Deputy Director at Root and Rebound. I am also an attorney here and part of the founding team. Our organization was founded in 2013, focused on how lawyers could reverse some of the horrible effects of mass incarceration on our communities. And so we're excited to talk about how that applies in the housing context today. So before I get into more about Root and Rebound, I wanted to quickly do a session overview if you want to go back in the slide. So here you're going to see a little bit about what you all will be learning with us today, and hopefully we'll be learning from you all. So we encourage everyone joining the webinar to engage, to write in questions, to share experiences from your region across the country, because we know there's a lot of advocates on the ground working on these issues. So today, you will be learning about the housing rights of people with arrest and conviction histories, the legal avenues available for challenging unlawful housing discrimination, and excitingly, a lot of new strategies and growing strategies that advocates across the country are implementing to remove housing barriers for people with arrest and conviction histories. So that is a little bit about what we will be learning today. And these are some statistics we often share with folks, and for some of you it may not be a surprise, and for many it may be really shocking to learn that 1 in 3 Americans are now estimated to have a criminal record. That could be an arrest or a conviction history. That could be a very short interaction with law enforcement to having spent years and years locked up behind bars. And so Root and Rebound is here to serve anyone who has been impacted by incarceration and by the justice system and folks with records. So if you think about that, that is a lot of people in the community, and it's to the point that pretty much almost nobody can say they are not somehow connected to someone who has been impacted by the justice system. Now, how that affects our different communities and how those outcomes play out can be really different based on the income, based on the race, based on the policing, the sentencing. And so there's disparities that exist within that. And still, this is an issue that I think all people can in some way relate to and connect to in this day and age. We also note there that 750,000 individuals are released from prison each year in the United States. Over 90% of people will come out of incarceration and come back to their communities. And so it's really important to realize that the barriers that people face because of a record are not serving us. People will be coming home, and they're not just affecting those individuals, but they're affecting their families, their children, and the broader community's public safety when folks are unable to get housing, unable to work, unable to reconnect with family, which we'll be talking about more today. And then lastly, this number comes from research that initially was launched by the American Bar Association about the legal barriers that are written into our laws and at the state and federal level that discriminate lawfully against people because of a conviction history. And so they have documented over 48,000 legal barriers that actually lawfully discriminate against folks with records. So that's pretty tremendous when you think about already all of the web of uncertainty and challenges that naturally come along with returning to the community from incarceration, that our laws have actually set people up in many ways to fail. And folks are often not empowered with knowing what their rights are and navigating these barriers when they arise. And so we're hoping this conversation can be a spark to ignite more knowledge in the community, to spread not just the barriers, but actually the power to overcome them and opportunities to navigate them, and to hopefully change some of these laws as well. One other thing I wanted to notice, and why Root and Rebound believes that public education is so critical, is that there is only one pro bono legal aid attorney for every 10,000 Americans who cannot afford representation. So while we believe the law is a powerful tool, we also know that lawyers are not in any way a solution alone at all to mass incarceration and its effects on communities and families. And just hearing that number, one lawyer for every 10,000 Americans who cannot afford representation, I think is pretty impactful, because it means that we need everyone to be aware of how the law is affecting their lives, their communities' lives, the individuals who you serve, regardless of whether that's in a social services capacity, a health work capacity, legal or advocacy, that it's important to understand the way that laws impact our communities and those we serve. Next slide. So a bit more about Root and Rebound and our work here. I briefly touched upon this, but our mission here is to really flip the script on lawyering and transfer power and information from the policy and legal communities to people who are most impacted by our criminal justice system. And we do this through three main avenues. The first is public education. The second is direct legal services and legal advocacy. And the third is through policy and other systemic reform efforts. So we really look at the way mass incarceration has impacted communities from a holistic model, understanding that individuals who are navigating these issues day in and day out need that direct support, that hand-to-hand support, and at the very highest level of our laws and policies and practices, in this country, that those also need to change. So we see the work that we do directly with individuals as deeply and necessarily connected to the work we do at the policy level. And our policy and education work is driven by the relationships we have with community members who have been impacted by the justice system. And so before I transfer over to my colleague Chloe to get into more of the details about these legal barriers and protections, I wanted to just have some shared language about fair chance housing, why we use that term and what it means to us at Root and Rebound. So for us, fair chance housing means that we shouldn't be putting up additional barriers to an already limited housing stock for people who have been involved in the criminal justice system. As we just discussed, 1 in 3 people has a record. That's anywhere between 70 and 100 million Americans who have a record, where that is affecting their opportunity to become stably housed. And as many folks on this call, I'm sure, are deeply aware of and working on these issues, we have an affordability crisis across the country. We do not have affordable housing. We don't have enough in every single place in the United States. There is no state that has enough affordable housing for the people who need it. So while we won't be getting as into the details of expanding the housing stock in this presentation, we know that's a deeply connected issue. And with what currently exists, fair chance housing really is a belief and a philosophy that all humans deserve stable housing, all humans deserve to be in safe housing, and that a criminal record shouldn't be posing additional unnecessary barriers for people to achieve that stability. Okay, so I'm now going to pass over to Chloe Noonan, who's going to be diving into a legal overview about fair chance housing and some of the laws and protections that exist.
Thank you very much, Sonia. Next slide. I'm going to start out by giving an overview of the types of housing that we're talking about when we discuss fair chance housing and access to housing for folks with arrest and conviction histories. We can be talking about private housing or federally assisted housing. So when we say private housing is owned and operated by a private landlord. It can be market rate or affordable without receiving a federal subsidy. Essentially, private housing is any housing that is not owned and operated by the government. It can be owned and operated by a corporation, a nonprofit, or an individual. Some examples of types of federally assisted housing, though this is not an exhaustive list, these are the types of federally assisted housing that often come up that many folks are living in or trying to access across the country. They are public housing, the Section 8 voucher program, and project-based Section 8 rental assistance program. It's important when applying for housing applicants to find out whether they're applying for private housing or federally assisted housing, not just because the application processes will be different, but also because their legal protections and opportunities to assert their rights, if they're facing discrimination because of a record, those opportunities will be different depending on what type of housing it is. So if someone is required to go through the local public housing authority or city or county to apply for housing or to apply for a voucher, then the housing is going to be considered federally assisted housing. If someone is not sure whether they are applying to private or federally assisted housing, they can ask the relevant listing agent, realtor, property manager, owner, or other contact listed on the housing advertisement. Folks can also go online and look up the property on the internet through HUD's website to determine if the property is federally assisted housing or not. And doing that research in the initial stage of applying for housing is really important. Next slide. So now I'm going to talk a little bit about the barriers that people with records face in accessing federally assisted housing, accessing private housing, and then barriers that apply to all kinds of housing as well. So for federally assisted housing, there are only 2 categorical lifetime bans that are based on convictions for federally assisted housing. Those are listed here. If someone is convicted of methamphetamine production in federally assisted property, if someone is convicted of a sex offense which requires them to register on lifetime registration, those are the only two legally required bans for getting into federally assisted housing. In addition to that, there's a temporary ban for people who have in the past been evicted from federally assisted property due to drug-related activity. There's also bans for people who are currently using illegal drugs, and the time limitation on that is until a reasonable time has passed since illegal drug use. So nationally, for federally assisted housing, there really aren't that many legally required bans on people with records accessing housing, but the majority of barriers and admissions to federally assisted housing are actually are not legally required, but are at the discretion of public housing authorities. And if you'd like to learn more about what this discretion looks like, a great report I recommend looking up online is When Discretion Means Denial, which is a research report that was published a couple years ago by the Shriver Center on Poverty Law. This research found that when public housing authorities have the discretion to deny someone housing based on arrest or conviction history, that discretion often leads to people being denied housing. Next slide. To talk a little bit about barriers to housing stability that can come up for accessing private housing, one of those barriers is the proliferation of background checks. So across the country, private landlords have, over the years, increasingly relied upon background checks that are conducted by private background check companies as part of the housing application process. The reports produced by background check companies often contain mistakes and errors, incorrect information, that essentially incorrectly reports the conviction history of the applicant, and this can lead to the applicant being denied housing based on false information. Groups that have conducted testing often find there's widespread discrimination in terms of who is subjected to a background check in the housing application process, finding that rather than submitting everyone who applies to a background check, housing providers will often specifically target for background checks people of particular races, genders, who might have conviction histories, but that it's not uniform across the board, and that people of color are more likely to be required to go through a background check. I'll also note that because there are so many background check companies across the country, even though they are regulated, those requirements are not enforced uniformly and are not enforced very well. And so this can make it harder for renters to make sure that landlords are evaluating their applications based on correct information about themselves and their conviction histories. Another barrier to private housing is that at present there are not statewide ban-the-box laws or other statewide fair chance housing laws on the book in any state across the country, and there are a few local ordinances that do protect people with records as they're applying for housing, but there are very few. Only 9 cities at present have passed local ordinances. So as a result, there are often not many state or local legal protections that can ensure that housing applicants with records are getting a fair chance to access housing. Next slide. Thank you. So these are additional barriers to accessing housing that can apply to both federally assisted housing and private housing. Other legal grounds for denial can be convictions relating to drug-related activity, violent activity, and threats to health, safety, or peace of other residents. That said, pursuant to HUD guidance from 2015 and 2016 that I'll talk about very shortly, landlords are supposed to and should consider mitigating information and proof of rehabilitation before denying someone with a record housing on these grounds. A couple examples can include in terms of the meaning of proof of rehabilitation and how that can help a housing application. This can be things like letters of reference from an employer, grades from school, certificates of completion of therapy or other programs, volunteering in the community, letters of support from a church. So this is essentially evidence of how someone's life has changed since the since the event or incident for which they were convicted. These can be great ways to demonstrate to a landlord that despite what might appear on someone's background check, that in fact they are an important member of their community and that the conviction has no bearing on their ability to be a good tenant. So now I'm going to talk a little bit about what legal protections currently exist and strategies that people with records, advocates, can use to enforce rights and fight against discrimination in housing. So at the top, we see on this slide a list of laws that offer protections for people with records as they are applying to housing in some capacity or another, or where the laws may not specifically mention criminal records as an area of protection, but because of related issues, these laws can be used creatively by advocates to enforce people's rights. So the Fair Housing Act is certainly going to be the main law that's been identified as protecting people as they apply to housing. And the HUD guidance that I'll talk about in a moment in 2016 conducts a fair housing analysis based on the Fair Housing Act. So in addition to the Fair Housing Act, there are these other laws, for example, the Americans with Disabilities Act, the Violence Against Women Act, and state civil rights laws, which may not on their own specifically address the rights of people with criminal records as they're applying for or trying to maintain housing. However, these laws address other types of discrimination protection, for example, areas of disparate impact or areas where policies or practices are negatively impacting people of a particular race or other protected groups. And through these types of protections, advocates can creatively utilize aspects of these laws to enforce people's rights. Another example I'll give with the Americans with Disabilities Act, for example, is if someone is applying for housing and their conviction is directly related to or connected to their disability or to past substance use, that can be a law that can be used to ensure that people are not being discriminated against when they apply for housing, and can be the basis for a complaint if someone is denied access to housing. So the second point here on HUD guidance that was published by the Department of Housing and Urban Development in 2015 and another in 2016, it says that landlords cannot deny applications to housing for arrests that did not lead to convictions. Landlords cannot issue blanket bans for criminal convictions or arrests without considering the nature of the crime or the basis for the conviction, how much time has passed, or whether the applicant is a threat to others. Landlords cannot create arbitrary screening criteria and cannot implement policies that unfairly impact particular racial or ethnic groups.
This is Sonia. I wanted to add something briefly to that point, and this slide, if you can go back just for a moment, because I think this is a lot of, it's heavy legal information, and for those of you who are lawyers, I'm sure it's clicking, and for those who aren't, I want to just make a point to underline it, that people who have been impacted by the justice system, and we said this and I want to say it again, are disproportionately Black families, Black people, people of color, Latino communities, people with disabilities, LGBTQ individuals, and people who have experienced violence. So those are the people who are being disproportionately impacted by mass incarceration. I sometimes hear the term hyper-incarceration used instead of mass incarceration because we've hyper-incarcerated particular communities over others. And so while people with criminal records is not in and of itself, in most places, a protected class, it hasn't been given that kind of level of protection from our law. The justice system has such a deep connection in how it's affected communities that have already been marginalized or disenfranchised for many, many years. And so this is why, as advocates, because we don't have protection specifically for people with records, but we know that background checks are often a proxy for racial discrimination and other forms of unfair and unlawful discrimination, we have to get creative with the laws that we are using in our tool belt to protect people who are wrongfully being impacted and being kept out of housing despite the fact they would make great neighbors and are wonderful people. So that's just something I want to underline again, that we don't have those protections for people with records as their own class, but there are so many connections to other civil rights laws that people have worked hard to pass, and that it's important for, as advocates, that we are making those connections in our work.
Thank you. Next slide. All right, so now I'm going to talk a little bit about background checks. So what information can private landlords consider in housing applications? What information can landlords who are running federally assisted housing consider? And what are the rights and requirements when someone with a record is going through a background check? So private landlords can access background information from housing applications, from private background check companies, court records, and other public records, as well as the internet. Public housing authority can also access information about someone's record from the National Crime Information Center, state and local police departments, other housing authorities, and drug treatment facilities if the housing authority suspects current drug use. When running a background check on someone, background check companies have to comply with the Fair Credit Reporting Act. And on the next slide, I'll talk a little bit more about what those requirements are. Next slide. So landlords and public housing authorities cannot use criteria for housing applications that discriminate against people for their race, color, national origin, religion, sex, disability, or family status. Sonia was talking a little bit before about the relationship between trying to access housing, experiencing discrimination, and all of these other protected categories. And then the second bullet point notes that background check companies must turn over reports on applicants and correct inaccuracies. So since background check companies across the country have to comply with the Fair Credit Reporting Act, there are some additional notice requirements that they have to follow when someone is being subjected to a background check and when someone is going to be denied the opportunity to access housing as a result of that. So people applying for housing with a record have a right to receive notice that a landlord is running a background check on them. They have the right to request a copy of the background check within 60 days of having their housing application denied. And they also have the right to correct errors in the background check report. I'll also note that the Fair Credit Reporting Act is a federal national law, and there are some states that have stronger protections for people with records that apply to background checks. So for our viewers, depending on what state you live in, your state may have more additional protections for folks. Next slide. So this slide maps out a little bit the steps that can be taken if someone is denied housing and believes they're discriminated against. And as I mentioned at the beginning, these steps can be a little bit different depending on whether the person applied for federally assisted housing or applied for housing with a private landlord. So if someone is applying to federally assisted housing, and they believe they were denied because of illegal access to their records or incorrect or illegal information, discriminated against in some way, that person should immediately submit a written request for a review hearing. A review hearing is an informal process, so not in a court, where people can challenge the denial of housing within the public housing authority. The hearing is conducted by a person called a hearing officer who is designated by the housing authority to represent the housing authority in the hearing. At the review hearing, people can make corrections to their records, give the housing authority evidence of the rehabilitation and other mitigating information, and challenge the denial of their housing application. After that process, if the person seeking to assert their rights is denied housing still after the review hearing, that person can file a complaint with the local HUD office. If someone is denied housing and it's with a private landlord, they should contact their local fair housing or legal services organization and file a complaint also with their local HUD office or state fair housing commission. Whether someone is denied housing in public housing or private housing, the first step should definitely be to reach out to a lawyer, and at the end of the presentation, we'll include a list of national organizations and resources that folks can look at to try to find a local free or pro bono attorney to help them with their case. And the majority of legal aid organizations across the country do have housing units with attorneys that focus on protecting people's rights as they're applying for and trying to maintain their housing. Next slide. And now I'm going to hand the conversation back over to Sonia to talk a little bit about housing policy reform and the different options for how improving access to housing for people with records can look in local jurisdictions, in states, and at the national level across the country.
Awesome. Thank you, Chloe. And before I jumped into that, I wanted to acknowledge a couple of the questions that have been shared through the chat box. Thank you to Matt and to Jennifer who submitted us questions. So briefly, I wanted to address those. One was, what states have additional protections for background checks? I definitely encourage for that question, if you have a specific state in mind, you can reach out to Root and Rebound afterwards, and we can get you that information and also connect you to a local legal aid or advocacy organization that has specific expertise on these issues in your state. Depending on different types of rules that affect background check companies, it depends what state you're in. So there are about 9 states, I believe, that currently restrict conviction information that can be reported on a background check to 7 years. So that's not every state that has that, but many states say that conviction history information, or in those 9 states, conviction history information can only be reported back 7 years. We're based in California, as Scott said in the beginning, and we're one of those states. So we have stronger protections here in California. Others include New Mexico, Kansas, Montana, Washington, New York, New Hampshire, Massachusetts, and I believe there's Maryland, actually, and probably others that I might not know. But I would definitely encourage you to reach out to us afterwards, and we can connect you to a legal organization that has lawyers in your state to make sure that additional protections are known to you. There's also some states that have added that non-convictions cannot be reported, so that arrests that never led to a conviction cannot be reported. And for a lot of reasons, that's a good idea, and we believe a best practice. Even for states where background check companies can report arrests that didn't lead to conviction, it should not be considered by housing providers, and Chloe just described a little bit for why that is, because it doesn't give a finding of guilt, and again, it has a racially and other discriminatory effect on a lot of people when they're looking at arrests that never led to conviction. So those are just a couple examples of ways that states have built up protections that are not at the federal level, and I'm sure there's a lot of advocates on here who can then speak to even more protections at the local level. And then another question we received was that some apartment complexes can only have a certain number of formerly incarcerated people. Is that true? And if that's just for federally assisted housing, or does that also apply to private housing? It may be that that's happening in practice. I certainly would say that seems unlawful. So I would love to chat with you after this webinar to learn more about where you heard that, where in the country that was being shared, and what that is looking like locally, because I think that is potentially a practice that is being used, but certainly one that I think could be challenged. All right, so thank you guys for those questions. We'll continue to dig into them at the end of the presentation. I really appreciate all the engagement, and I see even more people coming in with resources, so thank you to everyone who's joining. Okay, so now I get to talk about some of the fun stuff, which is the amazing work that is happening from advocates around the country to reform a lot of the laws and barriers that currently exist. So there are efforts happening at all levels of government, at the state and grassroots local levels, and at the federal levels. A lot of this is happening in coalitions where groups that are doing community-based services and local advocacy and community organizing, along with elected officials, are coming together to move for better laws in their region. There are actually 9 cities that have so far passed a fair chance housing ordinance. The way those each look is a little bit different, and how they are trying to attack the issue of increasing access and opportunity to housing for people with conviction histories looks a little different, the vehicles, the types of housing providers that they are affecting, and so on. But this shows that there is a lot of exciting things happening, especially at the grassroots local level. We do not have those kinds of laws at the statewide level, but we are seeing them pop up more and more at the local level. So the 9 cities and counties, I should add, that have a fair chance housing ordinance currently on the books include Richmond, California, Seattle, Washington, San Francisco, City and County in California, Newark, New Jersey, Washington, D.C., Urbana, Illinois, Champaign, Illinois, Cook County, where Chicago is based, Illinois, and Portland, Oregon, which is the most recent city to have passed a fair chance housing ordinance. So this is really exciting that more of these are happening, that there is this local advocacy happening. Probably the strongest of those 9 that we've seen that has the most protections for people with conviction histories is in Seattle, where they essentially have found that because criminal background checks have more of a cost than a benefit in housing decisions, that they've just made them not able to be used in the housing application process. And there's legal challenges, so it'll be interesting to see what happens in Seattle, and for us as advocates to be paying attention to that particular ordinance. And then I also wanted to mention that Root and Rebound has developed wonderful relationships with Just Cities, which is based here in Oakland, as well as with Vote, which is based in New Orleans, both of which currently are leading coalitions to pass fair chance housing ordinances locally in New Orleans, and then Just Cities is working in Alameda County, including the cities of Emeryville, Oakland, and Berkeley. So those are great organizations we partner with that are leading these coalitions. In addition, we partner frequently with the National Housing Law Project. They are actually in the process of developing a toolkit that will, I think, be available later this year about template laws and ordinances and best practices and things that they have learned as a national policy organization working with grassroots community-based organizations trying to push for local fair chance housing laws. So when that's available, we'll be sure to share that with the Annie Casey Foundation, and hopefully there's a way to get it out to everyone listening today. And then at the federal level, there are some good things happening too, which is probably a little hard to believe, but there is actually currently a bill that is being proposed by Senator Kamala Harris and Representative Alexandria Ocasio-Cortez, and that is actually focused on reforming some of the barriers to federally assisted housing. So there's a fact sheet about that also available on the National Housing Law Project's website. They and the National Low Income Housing Coalition have been involved in advocating for that and putting out really helpful know your rights, sort of plain language information about that federal bill that's going through. And that is really focused on reforming, again, some of these barriers and abuse of discretion by federally assisted housing providers and public housing authorities. So you can check that out. Next slide. Another way that we have seen really creative advocacy being done that we wanted to highlight is a project that's led by the Vera Institute of Justice called Opening Doors to Public Housing Initiative. And that project is focused on actually having Vera Institute provide technical assistance and directly consult with public housing authorities. And while theirs is being done through a national initiative in particular cities across the country, this is actually something we believe a lot of advocacy groups could model at the local level to actually be sitting down and having conversations with their public housing authorities. As Chloe mentioned, a lot of the ways that people with conviction histories are being kept out of federally assisted affordable housing programs is the discretion of local public housing authorities at the city and county levels. And so they have a lot of power to open the doors and to close the doors. And so if you're interested, I'm sure, Vera Institute would be happy to talk to folks about their experience and the different stakeholders and constituencies they bring to the table. And we think that's just a really creative advocacy vehicle that we hope to be seeing used more and more and more in addition to some of these local fair chance housing ordinances that are going on. And so some of the places where they're working is in San Diego, in Delaware, in Louisiana, in Oklahoma, and some other places. So again, if you're in those places, just know that there are groups to reach out to, and if they're not working in your community, because there's many more communities than they are able to reach, know that those might be some advocacy models to look at and some strategies to look at. Next slide. So here we listed just a few additional resources from Root and Rebound. As I mentioned at the beginning, and Scott mentioned, we're a national organization, so we develop resources all across the country and state-based resources as well as federal resources about barriers, legal barriers because of a conviction history, and how to navigate those and overcome those barriers. So joining our mailing list is a great way to just stay up to date about different resources that we are creating and developing both here in California as well as across the country with a lot of partner organizations. Specifically, our Fair Chance Housing Toolbox, which has not just template slides available, but also videos on different issues related to fair chance housing. It has some fact sheets for certain states that we've partnered to develop state-specific fact sheets. So there's a ton of information at rootandrebound.org/housing-toolkit. So I would definitely encourage you to check that out. A lot of the resources and the information we're sharing today can be found in that toolbox. And then lastly, we mentioned this one again, since looking at resources that are nationally applicable, we have just created a reentry guide for people who are coming out of federal prison because of the First Step Act. And while some of the information in that guide is focused specifically on people coming out of federal prison, a lot of it is just generally know your rights information for folks with conviction histories around the country who are in the reentry process to understand their rights to health care, to benefits, to housing, to employment, and where there's federal laws impacting someone's rights and where some states might have additional protection. So it's just a really practical guide aimed at people who are directly impacted. And we are also creating what we call Roadmap to Reentry legal guides that cover many areas of law and life and how a record affects a person in those different areas of life. We have a really robust Roadmap to Reentry legal guide in California. We're currently developing in the final stages one in Connecticut, and we're currently working on one for South Carolina that should likely be available in the spring. So if you also are interested in creating similar types of state-specific toolkits or know your right guides, legal guides, based on the resources available on Root and Rebound's website, please reach out to Chloe and myself, and we would love to chat more to see if we can make that possible together. Next slide. And this is just a shout-out board to some other organizations, especially national organizations that are publishing some really great information and advocacy resources, especially for service providers and for advocates. National Hire Network, which is a project of the Legal Action Center, the Shriver Center on Poverty Law. Chloe mentioned their really great report, When Discretion Means Denial. The Veer Institute of Justice, the National Housing Law Project that is helping local advocates across the country work on fair chance housing policy, and then legal organizations as well. There's some national groups, the ACLU, the NAACP Legal Defense Fund, and the American Bar Association that have connections to pro bono work on these issues, and then local legal aid. Most states do have local legal services organizations that have a housing unit. So it's great to get to know who in your community, who are the lawyers who are serving low-income communities on these issues, and get in touch with those legal services organizations. And Root and Rebound is happy to be a conduit and an introduction if you're not sure where to look. Okay, so I think we're going to pass it over back to Annie Casey Foundation just to share how people can continue to submit questions, and then we have the last 10 or 15 minutes to answer any questions that you all have.
Well, we have a host of questions here, which is a great thing. And there's been a lot of excitement in the chat box during the course of your presentation, including one who is really, really appreciative of the additional resources that you provided. But let me start with one of the first questions that came up, and this was one that noted that property managers are increasingly implementing stricter standards than public housing authorities. And the question was, what are the impacts, if any, on housing rights in the federally assisted housing?
So just to be clear, the question is how are private landlords' behaviors impacting public housing behavior?
Federally assisted housing, yeah.
Yeah. Yeah, that's an interesting question about how they're actually impacting each other, and one I don't feel like I can really perfectly answer. That being said, I saw someone, for example, mention the crime-free housing movement that's been happening, which is really a coded way to discriminate against people with records. So we've definitely seen that there has been in the private housing community a resurgence of this anti-criminal record rhetoric and behavior in practices. So yeah, it is disturbing when that's happening, and I think a big way that we're trying to work on that is to have more education, to have honest conversations with housing providers about what those concerns are, and also to educate them about the liability they face. I think often these movements happen and housing providers don't realize they're putting themselves at risk as well by having such intense discriminatory policies. So it's definitely something that I think a lot of advocates around the country are looking at, and we've spoken to some law firms that are interested in litigating those policies. And so if you're seeing those in your community, again, we would encourage you to reach out to Root and Rebound so we can talk about strategies that you're using locally to fight against those policies that private housing landlords have put in place, and ways that lawyers could also potentially be helping and supporting that advocacy work. So that's something we've seen. I don't know, Chloe, if you have anything additional to add, or also if folks from Scott, if you've heard of anything related to this.
This is Chloe. I don't have a ton to add. I think there's certainly a relationship that can be acknowledged between landlords increasingly using background checks in their housing admissions process, and the proliferation and increased number of background check companies that are out there, which in turn makes it more difficult to enforce the regulations that exist and that restrict what background check companies are able to do with information that they're able to include. And I do think that even if it's more of a kind of informal cultural relationship, that private landlords relying on background checks and implementing these anti-criminal record policies, that can have an effect on the accessibility of the housing stock in cities and towns across the country as a whole, even if there are federally assisted housing providers within that same community that are, subject to different rules.
Great. So there are a number of questions here that are related to background checks, and I'm going to try to I'm not going to put them together, but I just want to ask them in tandem. One is more of a question of clarification, and it's really about what is the threshold for denial? Is it convictions or arrests? The second one is about if folks submit proof of rehab completion and then they are denied, are there next steps? And then the third one, and I think you talked a little bit about this early on in the presentation on certain pieces of your background, but is there a limit on how far someone can go in your background check history that would impact your denial?
So I can start by addressing the last question: how far back can the background checks go in someone's arrest or conviction history, and what convictions can be considered? The answer to that, in terms of what background check companies are allowed to report, is going to likely vary depending on the state that person is living in, because in addition to the Fair Credit Reporting Act, there are these state-based laws that offer more protections. So for some states, the look-back period might be 7 years. For some, it might be different. So in order to determine how far back landlords are able to consider this information and whether background check companies are allowed to report it from, 10 years ago, 20 years ago, beyond, it's really important to look at the local state laws where the housing applicant is living.
And I'll add to that, this is Sonia, that the Federal Credit Reporting Act right now has an indefinite look-back period. So that's one of the issues, is that some states might be silent on this, but our federal law allows for an indefinite look-back period. So states have to proactively, at this point, until FCRA might change, they have to proactively create their own limits on how far back they believe housing providers should be able to look at a conviction history. So yeah, I just wanted to add that, and those are those 9 states that I was mentioning, and I can get a more accurate list out if that's helpful. I'll make a note for myself about what those states are, and I believe all of those states that have created a stronger limit have created the 7-year limit. That seems to be where most of them draw the line.
And just a clarification on the look-back period, is that from conviction or from release from incarceration?
That also depends on the wording in the state. So some of them say from the date of conviction, some of them say from the date of release from supervision, some say from the date of release of incarceration, and some say this or this or this. And that's actually that's being challenged in certain places as well. So each one of those 9 states that have that 7-year look-back period, the technicalities can be even more complex and confusing, which is makes it difficult to just give general, broad advice. But for those states, I would definitely look into what your law actually says so that you're able to help people know what should or shouldn't be showing up.
Okay. So we now have a couple of questions around different types of housing needs. One was whether there's any advocacy happening around fair chance in rural housing, and do the ag rules, Department of Ag rules use the same rules as HUD for its housing programs? And I'll let you do that one first.
Okay, so yeah, rural housing has some very, very different rules. For some of the specifics and technicalities, because it gets really technical, I would point back to the materials that have been put out by the Shriver Center and the National Housing Law Project. And again, I'm happy to send those specifically to anyone who would like them about rules affecting rural housing. I will say, in terms of advocacy efforts, that the Fair Chance Housing Act that's currently being proposed by Ocasio-Cortez and Harris is covering rural housing. And basically what that Fair Chance at Housing Act would do is it would direct the Secretary of Agriculture to revise their department's regulations regarding screening and termination of assistance procedures to be consistent with HUD's own policies and to be consistent with this new act. So it does address basically directs rural housing to follow HUD and to follow this new law. But it does have some technicalities that are different and complicated.
Okay.
This is Chloe. I just wanted to quickly address one of the earlier questions that Scott, you identified, where the question, I believe, was what is the threshold for denial of a housing application that we're talking about? Are we talking about arrests or convictions? And I just wanted to note that it's the 2015 guidance from the Department of Housing and Urban Development that talks about arrests, and essentially the guidance asserts that arrests should really not be a basis for denial of housing at all. And the analysis goes into more detail, but arrests really are not on their own probative of anything really, and have no bearing on someone's ability to be a good tenant. So we talk about arrest and conviction histories throughout this presentation, but I did just want to note that housing providers and landlords should not be denying anyone housing based on arrest.
Okay, thanks. So there's a data question here, and the question is about whether there's any data out there that shows the number of homeless individuals with criminal histories due to not being able to secure housing.
Yeah, I think that's a great question in terms of data. We do have some data. I'm going to see if I can pull some of that up right now on one of the notes on my earlier slides. But one thing I will say is that many people also enter the criminal justice system because of housing insecurity. So we know it's both a cause and effect, right? That housing insecurity and homelessness are both a pathway into incarceration because people are being arrested for status crimes, for living outside, for a lot of normal human behavior, but because they are housing insecure or because they are homeless, they are being targeted by law enforcement for a lot of different kinds of issues. And so there's a lot of sort of entry into the criminal justice system due to homelessness, and then obviously a criminal record then makes it even harder to get housing, which of course to me is sort of like, chicken and the egg, like why on earth, when we know the problem is housing insecurity, would you then make it harder to get housing as a solution? So that to me is just one of those things that keeps me up at night going crazy. But in terms of some of the statistics we have is that people with records face definitely an increased risk of housing insecurity and homelessness. I'm trying to see if we have specifically any numbers. No, it doesn't look like we actually have a specific number to that. I will look for that data because I want to have more of that data. So, and if others have it, please do share. We do have here that on a single night in 2017, it was shown that over 500,000 people were experiencing homelessness in the United States. About 40.6 million Americans live at or below the poverty line and struggle to find housing. And there's only 55 available units for every 100 very low-income households to get affordable housing, and there's only 35 available units for every 100 extremely low-income households, which have definitions based on federal poverty lines. So we have a little bit of data that I'm happy to share if it's useful, but it looks like someone just wrote in that the Prison Policy Institute has some great data on the connection between homelessness and incarceration as well. So thank you to Louis for sharing that.
Great. So we have about 90 seconds left, and I have two questions. The last one I'm actually going to leave and the answer is contact, root, and rebound. So that would be the answer to the last question, which is how can houses and advocates assist those seeking housing and affordable housing? And I'd say contact you to find out more information. But this question sort of involves big data, and it says, does HUD guidance apply to non-Fed subsidized housing? How might existing regulations be affected by the proposed HUD regulation on fair housing regarding disparate impact and the use of big data and algorithms on disparate impact cases?
Ooh, yay, I love that question.
60 seconds.
Yeah. In 60 seconds, I will say, yes, there's a huge connection across different regulatory agencies. The HUD guidance that we were speaking to applies to all housing providers because it is an interpretation of the Fair Housing Act, which applies to all housing providers. So that's the good news. The equivalence in Title VII and employment law is the Equal Employment Opportunity Commission has guidelines, and though we don't have it from the Department of Ed yet, they have published something called Beyond the Box about the belief that a disparate impact argument would also apply to the civil rights and education laws. So yes, exciting that it is being seen that way by multiple agencies, and we'll continue to be advocating across all of them here at Root and Rebound. Thank you.
Great. So as Chloe and Sonia said earlier in the presentation, there is one pro bono attorney for every 10,000 Americans in search of legal assistance. And so the work of their efforts through Rebound, the Fair Chance Housing Toolkit, and all the other work that they're doing are really helpful in trying to reduce the negative impacts of people in search of housing, especially for those who have been formerly incarcerated. I want to give a lot of thanks to both Chloe and Sonia for their leadership in the development of this toolkit, as well as the insights and their leadership efforts for making the ability of people who've had a record to return home and succeed in their communities. Many of you asked during the presentation. Yes, the webcast will be available soon. Look for it after Labor Day on the Annie E. Casey Foundation website, www.aecf.org. And on behalf of the presenters from Root and Rebound and on behalf of the foundation, I would really like to thank you for your great participation and engagement on today's webinar. Thank you.
Thank you so much.
That was